We're here tonight. I'm going to open up the July 25th joint meeting between the Planning Board and the Board of Selectmen, and we will start with the pledge to the flag.
Yeah.
Pledge
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I think I also have to open up the, July 25th, 17 Board of Selectmen's meeting.
Okay. All right. Okay. Just a couple of sort of housekeeping type of things. We are here to discuss Lot 27-2. Nothing that's happened previously, nothing that might be happening later on. This is the only thing that we're discussing right now. I handed out a little list. This would be the order that people will speak. I gave you spaces so that you could jot down some notes if you have questions, and I would ask you to hold your questions until the end, and then we can go around the table, and if you have questions, we can do it that way. I think we can go faster that way. I would like to give the floor to Mr. Burrell, since the selectmen have asked for this meeting.
Thank you, Madam Chair. I'd first of all like to thank all the parties for coming here tonight. This is, in my recent memory, the first time the Planning Board and the Board of Selectmen have had a joint meeting, so I thank you, especially since this is your night, regularly scheduled Planning Board meeting. As Barbara indicated, we're here for the Puzzle Lane situation, and I don't want to focus on any past unrelated events either. And I don't really want to even talk too much about how we got here unless it's pertinent. But the Board of Selectmen, as I think everybody knows, we're asked to issue a cease and desist order, which was proper in that it was our authority to do so. But what the Selectmen, what we all agreed is maybe we could come together and see if we could come up with a potentially different approach, an equitable approach, because one could make a case that the building permits that were issued might not have been properly issued, but the fact of the matter is, as I think anyone would who had a building permit, they relied on that to move ahead to do business. So I think that's important that we take that into consideration. We may still end up issuing a cease and desist order. That's something the Board of Selectmen will have to vote on, but I think a mitigation plan is something we want to look at that can kind of go hand in hand with that cease and desist order if that's what we decide to do. I'm probably just like everybody else who's on boards here. I try to do what's ever in the best interests of Newton whenever I vote on things. So I would never want to bend the rules. I don't want to break any laws. I'm sure we're all in agreement on that. But I think if we put our heads together and think out of the box a little bit, we can come up with a plan that's going to satisfy everybody involved. One of those things is I'm hoping we can set some sort of a firm timeline if there's things, there are requirements to meet, some sort of a calendar where whichever party has to meet those requirements can kind of rely on that timeline. Accountability is important to all sides, right? If somebody shows up with an incomplete thing, plan, whatever, form, that's going to slow things down. So obviously, if you're an applicant, you have to meet that requirements. But at the same time, I think we as a town also have to be accountable in order to make sure applicants have what they need so they can move forward. This is nothing new that I'm talking about here. So basically what that comes down to, and I'll stop talking here and we can move on, but I'm interested in knowing, and at times I have to put on my taxpayer hat, not just my selectman's hat, but as a taxpayer, this is potential revenue that's going to help my taxes, right? If it's anything more than zero, it's going to help my taxes. I'm not sure what the number is exactly, but how can we get to a point where we can satisfy the requirements of the planning board and at the same time, like I said, no bending rules, no breaking laws, but somehow move forward. So that's all I have to say to start us off. My thing would be what does the planning board require in this situation, and how can we figure out how to move forward?
I think it would be beneficial if the board could hear from the other people on this list so that they could maybe make a decision. So I believe that the next person on our list is Attorney Michael, which is Mr. McDonough's attorney.
Good evening to you all. It's been a while since I've been to Newton, but it is at least a pleasant drive here, and I appreciated your remarks, Mr. Chairman. Thank you. I did have the opportunity to review some of the items. I have not delved into, and I appreciate this, the entire history too far back associated with this project, although I have been before the boards previously a number of years back associated with Puzzle Lane and some of the issues that the board, I think, both boards fairly dealt with at that time. I am acquainted with, make sure I get the name right, Ms. Jennifer Rowden. If I'm mispronouncing that, I apologize.
It's
Ms.
Rowden.
Rowden. And I want to make it clear, and I'd sent a letter to the board as well, I don't have a huge issue with many of the concepts and statements that she makes. I want to make that very clear. I thought her letter, her note to the board, was reasonably accurate in discussing what the law is and what seems to have occurred. I need to remind the board of a few other things to try and bring this letter into focus, and I think I did some of that in my letter to you. The first is, I believe that we met the active and substantial during the first year. This project was approved back in 05, 06, quite a number of years ago, and right when it was approved, in fact, I think Mr. McDonough had started constructing some of the infrastructure, the roads, the drainage, as the process was moving forward. He had the right to cut trees and do some things on his land, but he couldn't build buildings, of course, until the planning board approved a site plan, which was approved. And that approval encompassed, most of the Puzzle Lane area as we know it today. And in fact, I believe 7 or 8 buildings, Coleman can correct me if I'm wrong, have been built. This project, we did active and substantial. That protected us for 5 years under the statute. Then I believe we also have completed substantial completion of the infrastructure and a good part of the development. That then vests the project. That's the way the statutes read. That vests the project. So I don't think we're outside the time frame that Ms. Rowden was kind enough to point out in her letter. We believe that we did it, and I believe that the town recognized that we did it because we were able to pull permits and continue with our development as per the approved site plan. So I think that everybody moved ahead in good faith, and I believe the town recognized and we recognized that we had met those standards. Once the substantial completion point has been met, I believe that we've met that, and I believe the town recognized that as well. We then move forward and are allowed to continue in accordance with our plan, which is exactly what we did. We brought forward a permit for a fairly substantial building. We've started it. We have a foundation in the ground based again upon a permit. I can't argue with the fact, I took a look at your ordinance. I've got the newest one, and I wasn't able to back up too far in terms of history. And I think what happened here with some of the setback issues that, again, Ms. Rowden points out, and I can't deny what the ordinance says. It talks about this 200-foot setback, but there's an interesting provision that's sometimes a little difficult to follow. It gave the planning board the power to reduce buffer sizes. And I don't know if the planning board recalls this, but I'm not sure. That was added in 2009. And prior to that time, the ordinance may have said they had the right to reduce not only the buffers, but some of these setbacks, because 200 feet is substantial. And I think the planning board, in good faith, felt that they had the ability to do that. Now, am I here to argue that somehow there's this equitable estoppel. That may relate to the existing buildings, but I proposed in my letter that my client is prepared to work with the town, not argue with the town, work with the town, as indicated by your chair, and go into the Zoning Board of Adjustment for an equitable waiver. Under the equitable waiver statute, if you've started construction in good faith, everybody thought that they were doing the right thing based upon how things have worked out at Puzzle Lane, and you've got actual construction in the ground, you're able to approach the zoning board for what's called an equitable waiver to have them bless what's occurred. I believe that the requirements for an equitable waiver will be met. In fact, I did the first equitable waiver case in New Hampshire the day after the statute was approved a number of years back. So I believe the criteria have been met. The part about going back to the planning board is a little rocky in my mind. I believe that we went there